All right. I have used this form many, many times, so I am very familiar with this form, but you guys are probably not, okay? So I'll try to go slow, okay? That way you can follow me, okay? I'll try to mute everybody as much as I can. The cell phones are the ones that are difficult to mute. All right, let's go back to the form again. This is non-residential. Oh, wait a minute. There is actually another form. I apologize. There's a third form. That might be the form I needed to use. Sorry about that. I think this might, yeah, that's the one I want to use. This is for apartment actually. So today we're going to talk about apartment complex that is 5 units or more. So if you are submitting an offer on behalf of a buyer on a apartment complex with 5 units or more, this is the form you want to use, okay? And let me open up the form. It says, do not use for properties containing less than 5 units. Now, if you have a 4-unit apartment complex, you use the CAR form. CAR has a similar form, okay? You do not use the AIR form. For 2 to 4 units apartment complex. Well, actually, you know what? Usually 2 is like a duplex, and then 3 is like a triplex. You could have a 4-unit apartment complex. If you have 4 units, do not use this form. If you have 5 or more, then you use this form. Okay? A lot of people are calling in using their iPhone. Okay? Next time, try not to call in using your iPhone if you can avoid it, because I think if you use your iPhone, I'm going to have to mute you every time because of all the background noise. On the right-hand side, this date here doesn't have any contractual significance. It's just for reference only. So you can pick a date here for reference, because sometimes when you prepare the offer, that will be the date you prepare the offer, but not the contract date, because the contract date is the date when both signatures appear on the form. Actually, it's the date on which the last signature between the buyer and the seller appears on the form. That is the contract date, okay? In fact, this is probably one of the BIE questions, okay? Or pay attention, that might be a test question for you. All right. And of course, you put in the buyer's name here. And then now, keep in mind the AIR form is very different from the CAR form. One of the big differences has to do with close of escrow. In AIR form, it is designed in such a way that the close of escrow date is relative to the expiration of the contingency date. Okay? Now, the default is 30 days after the waiver of expiration or expiration of buyer's contingencies. Now, so when you submit an offer like that, you don't have a close of escrow date. You basically say the escrow will close a certain number of days after the buyer's contingencies have expired. Also, in the AIR form, contingency removal is passive, not active. Many of you still do not understand the difference between passive removal of contingency and active removal of contingency. Let me explain in great detail here, so next time you don't ask me the same question again, okay? On a residential purchase, we use the active removal because we use the car form. On a commercial purchase, we use the passive removal because we use the air form. Okay, so what does it mean to remove contingency actively? You know, I have agents who's been doing this for 2 years now, who still don't know the difference between active and passive. Okay, I want to make sure that after today, everybody knows the difference between active removal and passive removal. I'll give you an example. Right. Okay, now let's say, for example, I'm a buyer's agent. I am submitting an offer on a 4-unit apartment complex. Should I use the car form or the air form? Car form. As I told you, the car form has active removal of contingency. What does that mean? All right, here's what it means. I submit the offer today using the car form, and that offer is to purchase the property with a 30-day escrow period. 30-day escrow, right? Now today is the 24th of July. Now if I submit an offer today, and if it's accepted today, I have both parties' signatures on the form. And then I have a 17-day loan contingency. I have 0 inspection and 0 appraisal contingency. What does 0 mean? It means I do not have any appraisal or inspection contingency. All I have is a 17-day loan contingency, right? Right. So today is the first day of escrow because we open escrow today, right? My offer is submitted and then it's accepted the same day and we open escrow same day. So 17 days from July 24th will be August 10th, right? So my agreement says I, as a buyer, have to remove the loan contingency by no later than August the 10th because it is an active removal. What does active removal mean? It means the buyer has to sign a piece of paper saying that the buyer removed the contingency. That's what active removal means. Got it? If the buyer never signs that piece of paper, does the buyer have contingency that remains all the way through close of escrow? That's right. I still have experienced agents confused about this. I will not name that person here, but I know that person well, and I have to hammer him on this one.
So this means
The buyer's deposit is safe as long as buyer never removed the loan contingency, even if the date had passed. Let's say the buyer never removed loan contingency, right? Now let's say you're the listing agent, right? And you just let things slide. You never insist that the buyer remove the loan contingency. And because we have a 30-day escrow, right? What day are we supposed to close escrow? August 23rd. We're supposed to close escrow August 23rd. What if buyer never removed contingency and August 23rd came and buyer said, I don't want to buy anymore? Can the buyer get his deposit back? Yes. Who's going to argue with me that buyer cannot get his deposit back if he never removed his contingency? No one is going to argue with me. because in order for the buyer to remove his contingency and thereby committing himself to buy the property or lose his deposit, buyer had to sign a piece of paper removing the contingency. This is what we call active removal. I don't want agents asking me about this again and be confused about this. Today we settle it once and for all. Okay, no one is going to ask me, Kenny, what is active removal? Now I'm telling you, that's what active removal means. All right?
So is there a set date to sign that?
Yeah, usually you specify in the contract, like I told you. In this case, we have a 17-day loan contingency removal period. Okay, so August 10th, and the buyer never removes, and even the listings agent, you let things slide, you let it go all the way to August 23rd and never insist that the buyer remove the contingency. It's your fault that you insist on getting the buyer's written removal. Okay?
So if the seller didn't get to sell that house.
Okay, why don't you wait till after it's over? I got a lot to cover today. Okay? Yeah. You can ask questions, but let's wait till it's over. Okay? Now, that's active removal. Do we have active or passive removal in air form? Let me tell you the bad news for you if you are the buyer's agent. We do not have active removal in the air form. We have passive removal. What does passive removal mean? Same time frame. You have a loan contingency that expires on August the 10th. If you are the buyer's agent, you don't pay attention, and your buyer's loan was not approved as of August the 10th. And then on August 11th, you found out from the loan officer that the loan was denied. What happened to your buyer's deposit? Gone. Now you see the difference between active and passive removal? Don't tell me next time you don't know the difference. All right? Because I'm tired of agents asking me the same thing, and they themselves get confused. This Wednesday, I'm going to testify in court, and one of the issues has to do with an experienced agent over 20 years who did not know that if you use a car form, it's active removal. Okay? Use an air form is passive removal. All right, I have to tease people because, you know, even experienced agents can't tell the difference between active removal and passive removal. The reason why you got to know that air form is passive removal, you got to have keep track of the deadline. If you miss the deadline, I don't want to be the one explaining to my buyer that I screwed up. I did not keep track of the deadline for my buyer. With the car form, it is not as important that you keep track of the deadline. But with the air form, it is extremely important that you keep track of the deadline because it requires only passive removal. Passive means that if you do not do anything, the contingency is considered to be removed. All right? If you sleep on it, it's removed. Then it means that your buyer is stuck with the deal, or he has to let the seller keep his deposit. Okay? All right. All right, next, okay, so basically, you know, with this form, usually I don't need to wait, usually it's relative to removal of contingency, so usually all I need is just 5 days or 10 days. Usually I use 10 days. This is my personal preference. 30 days is too long because by the time the buyer removes all contingencies, there's nothing else left to do but to close the escrow. So I use 10 days. Or you can use 5 days, whatever you prefer. It's totally up to you. The more days you have, the more protection the more time you give your buyer, but then the seller doesn't like it as much if you have too many days. So usually I just use 10 days. Okay. Now property here, you put in the address, the city, the county, the state. Here you have the physical description. For example, you can put down something like 6 units, okay, apartment complex, right? Something like that, you know. This is just a physical description, okay? It's not really official, but it's helpful. And then you put in what city, the county, the state, and then the street address. Legal description, usually I don't bother because it's so long. You got no room for legal description. The APM might be helpful. You know where you can get the APM from? You can get the APM from actually the, what do you call that, the real list. You go to your CRMLS or MLS listings or Bay East. Inside this MLS, there is a tab. It will either be called Real List Tax or Real List Tax 2. If you are with CRMLS, it is called Real List Tax. If you are with MLS listing, it is called Real List 2, Real List Tax 2. And if you are Bay East, I think it might be called Real List Tax 2 as well. Or maybe some other name, but it has the same database. So if you punch in the street address, it gives you the APN number. Okay? All right. Title company, you know, this is where you put title company's name right here, whichever title company you're going to use. Now, these days, just so you know, in Southern California, I use more than one title company now. I used to just use First American. These days, I also use Chicago Title. I want to have competition between the two companies so they can provide better service to me. I just don't want to limit myself to one company now. Okay. Now in the Bay Area, I still use First American, but I could be using Chicago Title in the future on some of my transactions. Okay, just so you know. But you know, you can use whatever title company you're comfortable with. You know, certainly you want to build relationship with the title company that you like, so they provide service to you. Now, the title company actually can give you a lot of services for free. They can give you the farm list. They can give you, you know, things that you need for your open house. Okay. 2.3 is about the description of what's included in the purchase price. Generally, it is quite comprehensive. You do not need to add anything. But since you're dealing with a 5-unit apartment complex, don't forget to ask the seller if he has any solar panel. You need to ask if the solar panel is included in the purchase price. Usually solar panels are leased. If it's leased, you can't include it in the purchase price. You have to transfer the lease to the new buyer. Okay. And then here's fire sprinkler monitor. You can specify whether it's owned or it's leased by the seller. It could be owned or it could be leased. So you have to check one or the other. Right? This has to do with fire sprinkler. And the buyer will need to negotiate a new lease with the fire monitoring company. Sometimes you know the ownership. You can immediately specify. Other times you don't know. You just say ownership will be determined during escrow. Or maybe there's no fire sprinkler monitor, so you check this box. Okay. So which box you check will depend on the situation you're in. Okay. All right. Let's see here. Purchase price, you know, just the total purchase price. In this case, it could be, you know, 5 units. 5 units, maybe it's $3 million. I don't. I just simply pick a number. All right, $3 million. Cash down payment, you know, down payment. That's including the deposit though. Down payment is if the guy has a loan though, right? Loan typically for commercial, let's say 40% down, so $1.2 million. Okay? And then the loan amount will then be 1.8, right? Okay. All right. That takes care of this one, right? Now, if you are not assuming any loan, it says strike if not applicable. There is a strike, something like a strike that you can use. This one right here, click it, right? But it asked me to select text, so I have to select text. So I'm supposed to strike this out. If it's not applicable, I am not assuming any existing mortgage, so this would not be applicable to me. So this will be stricken though. So that's why you have to learn how to strike things when you're doing AIR, okay? If you do this long enough, you know what to strike and what not to strike. Be careful because this is very sensitive. So you strike this out. So this is stricken because it's not applicable. You are not assuming any loan. So quite a number of things will be stricken now, right? So it says first to highlight, then I don't have any existing note that I'm assuming, so I'm striking a lot of stuff, okay? When I prepare this thing, because it is so sensitive, I have to be careful what I strike out, because if you make a mistake, you have to do this thing all over again, all right? You will not make a mistake, and be very careful. All right, so I'm going to strike this out because this is not applicable. And keep it clean though. Anything that is supposed to be stricken, you strike it completely. Don't leave anything out, okay? All right, strike it. All right, this is stricken. Got that? Okay. And then the deposit amount, you know, you check whatever is applicable. Usually it's about, commercial we can do 3 to 5%. Usually I like to do 3%, right? So it's 90,000 for this one, right? Okay. Usually I just select the default unless I have reason not to select the default. Okay. So this one talks about the deposit, right? Okay. And after both parties executed this agreement, the escrow has been delivered to escrow holder. Buyer shall deliver to escrow holder a check in the amount. So if you check this, you do not check this. All right. If you don't check this, then probably you need to check the other one. But this is more common though. The second one is actually more common, so I'm going to do this one. Okay. So we take care of the deposit here. Now there may be a situation where the seller is asking for additional deposit. Now it's actually more common in a commercial deal where the seller may say, okay, after a certain period, we want the buyer to deposit additional money. If this applies, you go ahead and fill out. If it doesn't apply, you have two choices. You can either strike this out, or if you leave it blank, usually in real estate practice, oftentimes you can leave something blank. If you leave something blank, the effect is the same thing as striking it out sometimes. Not always, but most of the time. If the effect is to, if the effect is the same as to strike it out, say for example, the one that I have earlier, what if I don't strike this out, I leave it blank? I could actually just leave it blank. It says strike if not applicable. That's why I strike it out. So I'm just following the form's instruction. Now this particular one is different though. The additional deposit, the form does not say strike if not applicable. So what do? I don't strike it. So I'm just going to leave it blank, because if I don't have additional deposit, then blank is as good as striking it out. Okay. All right. Just follow the instruction of the form. All right. Okay. This one says strike if not applicable, right? Now, what if my buyer has contingency, financing contingency? I don't strike this, right? And the offer is contingent upon buyer obtaining from an insurance company, financial institution, or other lender a commitment to lend the buyer a sum equal to at least. Now, if this is an SBA loan, oftentimes you can borrow up to 80% LTV. So I put 85% LTV. So I put 85%. So if I'm a buyer, I cannot borrow up to 85% LTV. I have the right to cancel. For example, if the lender comes back and says, based on your credit score, we can only loan you up to 70% LTV. So in that case, my buyer can cancel based on the loan contingency, because in my agreement, I told the seller that I needed to borrow up to 85% LTV. Okay? So that's how you fill out the financing contingency. So as you can see, the air form is very different from the car form. The way you work the air form is also very different. Okay? Buyer hereby agrees to diligently pursue obtaining new loan. The buyer failed to notify broker, blah, 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 within how many days following the date of, this is like the contingency period. Let's say, for example, for commercial, usually, we like to use something slightly longer, like 25 days. Commercial usually takes longer. Sometimes it could even be 30 days. So I put 30 days here for the loan contingency for commercial. Okay? So now this is a passive removal. So I have to pay attention to the 30 days. It doesn't even have a date. You have to calculate it yourself, right? We don't have any seller financing. It says strike if not applicable, so I'll go ahead and strike it, right? Because it says strike, right? Because it says strike, so I'm striking it. Okay? All right, strike it. All right? So this whole thing has to be stricken now. If you want to strike the whole thing. Don't leave anything out. This whole thing has to be stricken though, because they all pertain to seller financing, right? And then do I have to strike it? 6.3. If the purchase money deed of trust is off, whenever you see the word purchase money deed of trust, it has to do with seller financing. So I'm striking this as well. Okay. So I have to strike this thing. Okay. Strike it. All right. And deficiency judgment. This whole thing has to do with the seller financing. So I basically strike the whole thing all the way till just before the real estate broker. Okay. So this will be stricken. Right. Okay. So real estate broker. This one is self-explanatory. You do it yourself, right? And escrow and financing. You really do not need to pay a lot of attention to it yet. Maybe I save it for the next time. Today we don't have a lot of time to go over every single detail. Okay. Today I'm just kind of show you how to fill out form and not to explain the entire form to you. And then you got contingencies to closing. This is called the property information sheet. Property information sheet in air form is very similar to SPQ. If you know what SPQ is in car form, property information sheet is air form's equivalent to SPQ in car form. Okay? That's why you need to attend my seminar. That way you know what SPQ is. So usually we want the seller to provide the property information sheet to the buyer within 10 days of opening escrow. Physical inspection, you can change it from 10 days to some other period, depending on what type of property you're dealing with. But in many commercial deals, physical inspection could be anywhere from 10 days to 60 days. So depending on the type of property you have. So for a 5-unit apartment complex, I would say 30 days. Okay. This one, hazardous substance, has to do with environmental report though. 30 days is usually enough, so I'll keep it at 30 days. But if you need more time, by all means. Soil inspection for, usually we don't do it for apartment complex, so I leave it at 30 days. Government approval, probably I don't need it, so I'll leave it at 30 days. Conditions of title, this one is kind of important though. This one, I can leave it on 30 days. This one means that when the buyer receives the title report from the title company, the buyer has certain amount of time to decide if the buyer accepts the title report or rejects the title report. Okay, this one has to do with that. Survey. Survey has to do with if the buyer wants to do a survey of the property, they have 30 days to do the survey. Existing leases and tenant statements. Now, because I am buying a 5-unit apartment complex, this age is very important to me. 10 days is probably, you want the seller to provide the leases within 10 days is okay. And then after the seller provided, the buyer has certain amount of time to review it. Okay. Now this one also talks about tenant estoppel certificate. Now if you think that you need more than 10 days to get the tenant estoppel certificate ready, especially you have difficult tenants, you can put 20 days if you want. Okay. Owners Association, this deals with the situation where there's an HOA, so you need to provide HOA documentation to the buyer. For example, if you buy a commercial condo, then there is a HOA. And then there are other agreements that have to be provided. Now, these other agreements might have to do with the service agreement that the owner has with the repair company, like the roof repair or other types of repair company. Okay. Financing. Existing notes. We don't worry about it because we already strike the existing notes provision earlier. So we don't unless the form asks me to strike something, I do not strike it. I just leave it the way it is. Okay. Personal property, does the sale come with the personal property? If personal property is included in the purchase price, the buyer has 10 days to check the condition of the personal property. They mean title condition. Okay. Sometimes the personal property is included in the purchase price. But if you have a loan, do not make the personal property part of the purchase price for real property. Some lender does not like it, so that has to be a separate agreement. Destruction. This one talks about what if a bad incident happened, the building is destroyed or damaged. Then this provision will kick in. We're not going to worry about that. Okay. Material change has to do with, say for example, something happened during the escrow that caused a substantial change to the property, whether it's changed to the occupancy. Like for example, when the buyer first opened escrow, it was 100% occupancy. In the middle of the escrow, suddenly 3 units become vacant. That is a material change, right? So whenever you have a material change, the seller has to inform the buyer. The buyer has a certain amount of time to cancel the escrow based on material change. I would say if you have a vacancy that went from 100% to 50%, that might be deemed to be a material change to give the buyer the right to cancel. Okay. This one talks about the broker fee. The broker fee is usually by a separate agreement. Usually we do not put the broker fee into the purchase contract. Okay. All right. Now, there's one aspect about the air form that is different from the car form, is that on the car form, there is nothing mentioned about what if the buyer doesn't like what the buyer sees on the title report, whether the buyer can cancel or not. Now, this one on the air form, if the buyer doesn't like what he sees on the air form, it doesn't mean the buyer has the right to cancel. All it means is the buyer has the right to demand the seller to correct the title. It is only when the seller refuses to correct the title, then the buyer has the right to cancel. Just keep that in mind. Even if there's something on title the buyer doesn't like, the buyer cannot say, I want to cancel. No. The buyer has the right, has the obligation to give the seller an opportunity to cure it. Okay? Good. And number 10 is something for the escrow. We don't worry about it. Not so much for listing agent anyway, or the selling agent. Okay? But it's good to know there are, many of this stuff is actually for the escrow to worry about. We don't worry about it. Unless it has to do with things like keys, though, right? That's the job of an agent. Everything else is the escrow's job. All right, looks like, the rest is kind of like the escrow thing, so we don't worry about them. The representation thing, we don't worry about them. For the air form, they talk about mechanics lien, right? Car form, they don't even mention mechanics lien. That's the difference between car and air. Okay? They don't even talk about tenant bankruptcy in, I don't think they talk about tenant bankruptcy in a car form. In the case of air form, they talk about tenant bankruptcy. So if the seller is aware that one of the tenants is in bankruptcy, the seller has to disclose to the buyer. Possession, same as a car, it's actually delivered at close of escrow. And as far as buyer's entry, just like in car, the buyer has the right to enter the property, not a problem. And the rest are standard provision. And same thing, just like car, you can actually set an expiration date and the time for your offer. Okay, just like car. Same thing as car, you have liquidated damages clause in here. Arbitration clause, just like car. This one is kind of nice that it has the 1031 exchange provision. If you use car form, they might not have that provision in there. Car form probably does not have 1031 exchange provision, but air form does. So you do not have to specially draft a provision for 1031 if your client wants to do a 1031 exchange. Okay? All right. And then that's pretty much it. Now, if you want to add anything else, you're welcome to do that. You can either add them here or you can use an addendum. But I think as much as possible, use the open space here if you want to add something. Okay. And then on the signature page, you got the broker portion and the buyer portion. And then on here, you can actually insert the broker's commission right here. You see that? You can either do it here or you can do it as a separate agreement. Okay? And then you put in the broker's information and the seller's information. Okay? All right, that's pretty much concludes today's. Now, Anne, you have a question? I guess you forgot your question. Okay, never mind.
Just say if the agent make a mistake about the contingency, so he could be fired by the seller.
I won't fire you, but
by the seller.
yeah, it could. I mean, the seller's not happy with you. The seller could fire you, I suppose, right? I mean, it's important that you You don't make a mistake like that. It reflects very poorly on you as an agent. Okay? All right? All right, that concludes today's presentation. Next week, we're going to cover a similar contract, but it will be on, I believe it will be on commercial industrial. It's a standard offer. Okay? Thanks.